Welcome to this overview of trade secret law. I'm Professor Seth C. Oranburg from the University of New Hampshire Franklin Pierce School of Law, and over the course of 5 videos, we are going to cover the basics of trade secret law. Our 5 videos will include introduction to trade secret law, explaining why it exists and how to understand it generally. We're going to define what is a trade secret under American law. We're going to understand when a trade secret is misappropriated under trade secret law in America. We're going to evaluate how to protect trade secrets with contractual arrangements, and we're going to discuss what remedies are available for parties whose trade secrets have been misappropriated. So stay tuned for this 5-video series, and at the end of it, you should have a basic fundamental understanding of how trade secret law works. Are by definition revealed. In fact, the word patent comes from the root word to mean to reveal or disclose. You get patent protection by publicly filing a patent application. If the patent is granted, you get 20 years of exclusive rights to commercialize the patent. Trade secrets are, by definition, hidden. You get some trade secret protection by making reasonable efforts to keep information confidential. Trade secrets require no formal registration. In fact, they are protected by law to the extent that the information is not disclosed. The law requires that intellectual property consisting of trade secrets be kept secret and not publicly disclosed. So when it comes to trade secrets, you maintain the property right to keep them by protecting them from disclosure. Trade secret law existed in some manner since at least the Roman era. Historically, tort law protected trade secrets by providing a cause of action where one party wrongly misappropriated the trade secrets of another. More recently, intellectual property law conceived of trade secrets themselves as providing some property-like right to trade secrets holders, like the right to exclude others from using one's trade secrets. Also, contract law can protect trade secrets by agreement. Today, trade secrets are protected by a wide range of state, federal, and international laws, including state statutory law, namely the Uniform Trade Secrets Act, UTSA, as adopted by 48 or 49 of the U.S. states, by state common law, by federal statutory law, including the Defend Trade Secrets Act, the DTSA, by international law, including the Paris Convention for the Protection of Intellectual Property, and by various related law that protects property and prohibits theft and espionage. It's frankly impossible to learn all the laws related to trade secrets in any one class. However, I'm going to try to make your introduction to trade secrets as simple as possible by distilling all of the law into 2 simple concepts. First, what information counts as a trade secret? What is a trade secret? And second, what actions constitute unlawful misappropriation of trade secrets? If you learn these 2 simple things, first, what is a trade secret, and second, what is misappropriation of a trade secret, you'll be able to get started in protecting and practicing trade secret law. Before I conclude this introduction, let me briefly mention why the law protects trade secrets. There are 2 main reasons why law creates a property interest in trade secrets. First, the classic motivation for protecting trade secrets is defending commercial morality. The law historically played roles in defining and maintaining the morals of the marketplace since at least the Roman agora. Second, the contemporary motivation for protecting trade secrets is encouraging innovation. We encourage innovation through our various intellectual property laws. For example, the United States Constitution authorizes Congress to promote the progress of science and useful arts by securing, for limited times, to authors and inventors the exclusive rights to their writings and discoveries. More recently, modern law and economics recognize that the potential prize of earning some kind of intellectual property right to exclude others incentivizes the creation of useful ideas. On the other hand, there's at least 2 reasons why trade secrets are problematic. First, protecting trade secrets can limit competition. By granting an intellectual property right to one party, this comes with the right to exclude others from that commercial marketplace. This exclusive right inevitably reduces competition, which can result in higher prices for consumers or lower quality goods. Second, protecting trade secrets can limit employee mobility. It can be difficult to prove that a former employee misappropriated trade secrets, so instead an employer might seek to preclude that employee from competing in the first place. Contracts, like non-competition agreements, and to a lesser extent, non-solicitation and non-disclosure agreements and confidentiality agreements, protect trade secrets by limiting where employees can work and what they can do and say. And this creates some policy conflicts, especially where it implicates the ability to ply a trade. The debate about the theoretical basis for trade secret law is, to a great degree, rendered moot by the adoption of most states of the Uniform Trade Secrets Act. At least 48 states have adopted the UTSA. New York is the only significant holdout. North Carolina and Georgia adopted most but not all of the UTSA, and so are sometimes considered UTSA jurisdictions, and sometimes they're not. The property theory is embedded in the UTSA requirement of an identifiable trade secret. That's element one. What is a trade secret? The unfair competition or tort theory is embedded in the second requirement of what is a misappropriation. The UTSA defines misappropriation with some concept of wrongfulness, showing its tort-like nature. Accordingly, in virtually all U.S. jurisdictions, determining whether there is a claim for a trade secret is a two-step process. First, determine whether someone holds intellectual property known as a trade secret, whether someone owns some information in this sense. And second, determine whether there has been some misappropriation of that trade secret, where someone has wrongfully acquired, used, or disclosed trade secret information. Again, this misappropriation can only occur with respect to some existing trade secret property, which requires a combination of tort thinking and property thinking. When one understands the theories and philosophies that underlie a particular area of law, one can determine the proper application of law and can be more compelling in court. Different theories can be used to justify different claims that spin the outcome of the case one way or the other. When a court spins trade secret law toward the property theory, the tendency is to overlook whether a misappropriation has occurred by focusing on whether or not there is some intellectual property interest. Generally, it's in the plaintiff's best interest to emphasize the property view because it's easier to prove ownership. When a court spins trade secret law toward tort theory, then the tendency is to overlook the need for there to be an actual trade secret. Generally, it's in the defendant's best interest to emphasize the tort view because it's harder to prove wrongfulness.